Panel's on. Okay, we have Mr. Cohen.
Morning, Your Honor.
And we have Mr. Cummings. Well, actually, we have just passed the noon time, so we're now early afternoon. We think we have figured out the problem. There's a suspicion that our line may have been cut. We don't know that for a fact yet, so we appreciate you bearing with us today.
There's anything to get out of having to do this, Judge.
Okay, Mr. Cohen, did you wish to reserve any time for rebuttal?
Yes, sir. I'd like to reserve 5 minutes for rebuttal.
I will let you know when you arrive at that point.
Thank you,
You
sir.
may proceed, counsel.
Thank you. My name is Jeff Cohen. I'm at Carlton Fields, and I represent the appellant, Dr. Medina, in this matter. Dr. Medina is asking that the court reverse the final judgment entered in the plaintiff's favor. To begin, Your Honors, the trial court erred in concluding that a document known as a reassignment supplement was not required in this case for purposes of issuance of title. The facts in this case are, I'm sure, well known to the court. It's a motor vehicle accident where the driver's parent was listed on the title as a co-owner of the vehicle, and it is Dr. Medina's position that she should not have been listed. And the reason that she should not have been listed was because she did not sign this document known as the reassignment supplement. To get to whether or not that is required, requires the court to go through a number of Florida statutes as well as procedures that have been promulgated by the Department of Highway Safety and Motor Vehicles. And I'm just going to say now, I've been practicing this. I keep saying DMV when I mean DHSMV. It was the name of the group that I grew up with. So if I say DMV, I'm referring to the department of the DHSMV.
Good news. I remember them both.
Okay, great. Thank you, sir. So let me just kind of walk through it. The legislature enacted a chapter 319, that discusses the registration of vehicles in Florida, the titling requirements, and so forth. And again, these are all laid out in the brief, but I thought it would be helpful just to go through them really quickly. The first that's important is section 319.17. And what that section does is give the department the authority to adopt rules to implement the chapter in section 1. And in section 2 provides that the department shall prescribe all forms required or deemed necessary to the administration of the chapter. So there's a legislature giving the authority to the administrative agency for purposes of ensuring that title is granted and done the correct.
I do have a question.
Sure.
It appears, and please correct me wherever I have erred, that the thrust of the appellant's position is that the department erred in issuing the title, yet, and you wouldn't wish us to declare that to be the case, yet the department is not a party and there's no DEC action filed. I'm wondering how we get there in the process that presently appears, or is that an unnecessary step in your view?
I think it's an unnecessary step. The way that the issue was framed before the trial court was, the trial judge decided to have
no beneficial interest.
No, but to fast forward quite a while into the record, what wound up happening, and this really isn't germane to this specific issue, but eventually Dr. Medina's name was removed from the title. There's so the screen just went blank. I don't know if
no, well, I can see you. You're fine for me.
Okay,
so
well,
you're still
I'm not seeing, but as long as your honors can hear me, I'll answer the question. Eventually, there was an application to change the title and to remove Dr. Medina's name, which took place. There's some question as to whether or not that should have been done when it was done, but it was done. On the one hand, the other part is pursuant to Chapter 319, Section 25. If someone is put on a title in error, they can be removed. So I don't think that a deck action is necessary. If there were some additional action that needed to be taken later, I think there would just be forms that would be filled out, and that would be that. But it's not an issue that's been briefed by the parties on appeal.
No, that's okay. Because when I was looking at the record, I noticed that there was a point where the judge asked you for a statute, and I think you replied it would be in the pleading, and I was unable to locate it. That doesn't mean there's anything wrong with your advice. It just my technological skills going through the electronic record. So now you've identified it. I appreciate it.
Okay. Well, thank you, Your Honor. Going back then, so I mentioned 319.17. The next statute at issue, which is the one that the trial judge exclusively relied on, discusses applications for title and has two requirements. The first is an application for certificate of title on a form prescribed by the department. That comes up a couple of times. That's not an issue in this case. The evidence established that both Dr. Medina and Mr. Ponce signed the application for certificate of title. The second requirement, though, is a manufacturer certificate of origin. And this is important, Your Honors. It says, as required by Section 319.21 Florida statutes. Because in Section 319.21, the legislature talks about certificates of origin. And what it says is that a dealer selling a vehicle must deliver a certificate of origin on forms approved by the department. So again, the legislature is not saying what has to be in a certificate of origin, that it has to look a certain way or contain certain things. It's deferring that to the department to whom it is charged the responsibility for issuance of title. So from that, the department adopted formal procedures. And again, these were discussed in the testimony or in the record, and that's the document TL10. And it says very clearly that it's intended to establish requirements to ensure issuance of title. Section 3 is the issue that is the section rather that discusses the requirement for proof of ownership. That's the certificate of origin. And in one of the subsections, it talks about the fact that it has to be a conforming certificate of origin. And this actually comes up twice. There's two sections. It's in Section 3 and again in Section 4, A2. And what they say is that when the manufacturer's certificate of origin is non-conforming, a reassignment supplement is necessary to provide the information that is not in the conforming, that is not in the certificate of origin. And later on in TL10 in the definition sections, what it says is a non-conforming certificate of origin is one that doesn't comply with the elements of a federal odometer disclosure statement. And there was testimony in the record about what that is, and that came from the DMV representative who testified at trial. And those requirements for of the federal odometer statement are that not only do you state what the mileage is, but it has to be dated, verified. There have to be specific warnings that it's the signature is pursuant to perjury. It's subject to perjury. There have to be a reference to whether the actual mileage is being disclosed or the non-actual mileage is being disclosed. So again, that's set forth in the testimony, but it's also consistent, Your Honors, with the federal law, which is laid out in 49 CFR section 580.5, which was adopted in chapter 319.225 as federal requirements. So that's pretty much the bottom line here. And what the testimony of the DMV rep was that the manufacturer's certificate of origin, when it's non-conforming, the reassignment supplement provides the additional information about the vehicle mileage. It's a signed document that contains all of these requirements, and it becomes part of the certificate of origin. So at the end of the day, even if the court were to decide that section 319.23 requires a certificate of origin, this document when the certificate is otherwise non-conforming, becomes part of the certificate of origin. They're not inconsistent in that regard. So again, this is, like I mentioned before, this is completely borne out by the testimony of Mr. Frederick, who is the DMV representative who testified at trial, who also testified in the absence of a signed reassignment supplement, title cannot issue. That testimony is confirmed by both the dealership title clerk who testified and by the notary, in fact, the notary who obtains signatures on documents. In fact, the notary even said that he's done hundreds of these. Reassignment supplements are always in the package, and that, you know, I mean, he'd be stunned to have a situation where a reassignment supplement was not needed.
Can I ask you this? If the title should not have issued, in fact, it did, is there some concept that the title is void?
Well, that's actually a question that the trial judge asked. The title was improperly issued, and she should not be deemed the co-owner subject to vicarious liability, and her name should be removed from the title pursuant to section 319.25. It was erroneous, and this is kind of where you get into when the Christensen Supreme Court case, which was, you know, talked about a lot in the case. It has, you know, some application marginally. The primary holding about intent, possibly not so much, but it does talk about naked title pursuant to a faulty transfer. Does not subject someone to vicarious liability. This was a faulty transfer because the testimony established that Dr. Medina did not sign the reassignment supplement, so she should not be found to be vicariously liable. On
that point, you have indicated that a new title issued. Is there anything in the law that has a relation back theory that says it supersedes it as of the date it was issued, or does it take effect only on the date the new title was actually issued by the department?
I don't.
And I say that with
I don't know of a site to give Your Honor for that. However, if she should not have been on the title, then she should have never been determined to be an owner subject to vicarious liability.
Well, apparently she signed, and the notary witnessed her signature for the title. Is that correct?
She signed an application for a certificate of title.
Okay.
But she did not sign the reassignment. Our position is the
legal value of a TL10, when on its face, it says its purpose is to basically provide information and instructions to other, for want of a better term, executive branch agencies that do business or do transactions with this department, whether we DMV or whatever, it is. I mean, it doesn't stand on its own. It's a form that they promulgated to tell people, here are the way we view it. I mean, what effect of law would that have? And I guess that's the first question, if any. The second question that you point out, Mr. Fredericks testified, which kind of goes back to my original question, in that I don't know that he's authorized to bind the department in any action, since the department's not a party and they haven't designated him as their spokesman. He is merely an information source. I'm having some difficulties there, and that's why I want to ask you, because I won't get another shot, and I'm hoping our power lines don't get cut again before I have to come back and do this. So if you could help me out, I really appreciate it, Mr. Cohen.
Yes, sir. With regard to the first question, just in the description of TL10, the procedures are designed to...
at the top of the document, it says it. It publishes itself. The procedure provides information and instructions to assist employees, is the way I read it.
Right, but it assists them in terms of establishing requirements to properly issue title. So it is telling the people who work for the department these are the things that you have to have before you can issue title. So
Well,
one of
telling
those documents is the reassignment supplement.
Okay.
And with respect to Mr. Frederick, first of all, I mean, whether or not Mr. Frederick is binding the department, TL10 would bind the department because it's definitely their form, number one. And number two, he testified that he was there to testify as to the department's documents, policies.
Well, if he's nothing more than an opinion witness, the trial court can decide to believe or not to believe him, right?
Well, the judge can most certainly do that, but even disregarding
if the department was a party, that would be an admission of a party. Be a little different.
It would be, but I would agree that it would be a different circumstance. But even if just using him as a lay witness with experience doing this for years and years and years, his testimony is instructive and persuasive, and it's also fully consistent with all of the other testimony, including the testimony of the notary who goes out and does these, gets these documents supposedly, on all of his auto transactions, as well as the person at the dealership. So I know I'm running up against
15.
Right. So
and just I took off 30 because I was taking up some of your time. So you're well past 15, but I want to let you know before you invade the rest of your time.
I'm going to use 1 minute then, just very quickly on the issue of whether or not Ms. Medina, Dr. Medina, signed the document. It's our position that the handwriting expert's testimony is unrebutted, and that no fact finder could conclude that she signed that document. And with respect to
the correct.
I'm sorry.
That's the supplement when you say
that's correct. That's correct. And then with respect to the other issue, the limitation of damages under Section 324, obviously that's not something we could ask this court to revisit in the first instance. So the request that we made was for a certified question or for en banc. The plaintiff said that it wasn't preserved. We included in our rebuttal that it would be futile to do so. But with that, I'll reserve the balance of my time.
Thank you, counsel. All right, stop, clear. Okay, we are ready. Is it Mr. Cummings? Is that correct?
Yes, Your Honor.
You may proceed, sir.
Thank you, Your Honor. May it please the court, my name is Sean Cummings. I represent the appellee, Jay Davis. And there's two issues that I'd like to discuss this afternoon. The first issue is whether the reassignment supplement document is a required document for title to issue. And then the second issue is whether the appellant is entitled to the statutory damages cap, which will take much less time. Regarding the first issue, the appellant—
I think I know who wrote the opinion.
Excuse me, Judge?
I think I know who authored the opinion in question.
I think you do too. In fact, I think there may be two of you who are very well versed on that opinion in the Ortiz case. Judge, regarding the first issue, the appellant's argument is really a two-part argument. The first part of their assertion is that there's an authoritative rule that requires the reassignment supplement under certain conditions. And I'm going to talk about whether that is actually an authoritative rule in just a second. And then the second part of their assertion is that the interpretation of this so-called rule is entitled to deference by the trial court. So let's start with the idea of whether there is an actual authoritative rule in the first place. And Judge Casanueva, you hit the nail on the head. The issue here that we have to figure out is where does this rule come from and what kind of authority it should be given by the trial court. And that analysis starts with Chapter 120 of the Florida statutes. It's the Administrative Procedure Act. And it's referenced in Florida Statute 319.17, which was referred to by Mr. Cohen. 319, let me talk about the Administrative Procedure Act first. That act gives an agency such as the one that we're talking about, the DHSMV, it gives an agency like that authority to prescribe rules to do its business. And if the agency goes about that rulemaking process the correct way, then that rule essentially becomes like statutory law. It's given statutory effect. But it's a very lengthy process to establish a rule under Chapter 120. I think it's 120.54. You have to post the draft of the rule, allow public commentary, incorporate the comments into the final draft of the rule. I think there's a hearing. The court's probably familiar generally with that process, so I won't go through it. But once you do that, an administrative rule established under that process is authoritative. And the agency was given authority to promulgate administrative rules. That's what Mr. Cohen was talking about in Chapter 319.17. The legislature does give the DHSMV the authority to go through that process and establish a rule, but they didn't do it. That's not what this rule is. What we're talking about here is a small section, as you pointed out, Your Honor, in a guidance document, what I've called an internal procedure. That is this TL10 that we're talking about. And right in the description and use, as you've pointed out, it says this document, this policy is created for information and instruction to assist employees of several different executive agencies: the tax collector, the license plate agency, the DHSMV, etc., on how to issue a title. And what the appellant has tried to do, both below and now on appeal, is to essentially cloak this internal procedure, this guidance document, with the type of authority that an administrative rule would have if it were established under Chapter 120. And that's just improper. There's no authority that's been cited to say that this internal guidance document should be given that same type of authority. I'm not aware of any that says that. And it makes sense because Chapter 120.54 lays out the procedure for establishing that type of a rule. And that's not what was done in relation to this policy TL10 that the appellant is relying upon to say that this reassignment supplement is a necessary document. So that's the first point, which is that this procedural guidance document doesn't actually have any authority, any legal authority at all when it comes to what's necessary for issuing a title. It's a guidance document. And by the way, if the court accepts that position, which I think it must, the entire rest of the appellant's case fails. Because if the reassignment supplement document isn't statutorily required, then it doesn't matter whether Medina signed it or not. Title issued under the requirements in Florida statute, which is what happened. And that takes us to the second part of appellant's assertion, which is the issue about deference and how deference should have been applied. And so factually what happened at trial is an employee of the DHSMV, Mr. Ritchie, testified. And he testified that this internal procedure, this guidance document, requires a reassignment supplement under certain conditions. And it's the appellant's position in their brief that the trial court is required to give great deference to that testimony, which they amount to the agency's interpretation of this rule. And the cases they cited, and by the way, this isn't even a rule in the first place, so I don't even think we get there. Once we establish that the rule being relied upon doesn't have any authority, then the deference we give to it doesn't matter. But assuming that there's somehow
is this on that point, assuming that it's a rule, the people seem to have spoken by amending the Florida Constitution by enacting, Article 5, Section 21, that tells us that we don't defer, we give it de novo.
It is absolutely
a rule. A state court may not defer to an administrative agency's interpretation and must instead interpret such statute or rule de novo. So that has been the rule since 2018.
And that's consistent with what the Christensen court said in the Florida Supreme Court, Christensen versus Bowen, which certified this question and said that this is a de novo review. It's a question of law and it should be reviewed de novo. But even just to talk about this deference issue, and I agreed, Judge Castanueva, I think you're absolutely right. But
I've been reversed before, so.
But I do also want to address the assertion that was made by appellant and show the court why it's wrong. The appellant relies on, the main case is the Brahman Cadillac versus DHSMV, and then it string cites 3 or 4 other cases. And what it says is that, and I'm quoting it, an agency's statutory construction is entitled to great weight and is not to be overturned on appeal unless clearly erroneous. As Your Honor pointed out, I think that's the wrong standard. I think it is de novo. But even in looking at what those cases say, they say that it's an appellate court that gives deference to an administrative law judges. So if you have an administrative dispute and you go up to Tallahassee in the Division of Administrative Hearings, and an ALJ interprets a statute, which, by the way, I would include a rule that's established under Chapter 120. I think that's also inclusive. I think that's given statutory authority, not what we're talking about here. But an ALJ's interpretation of that is given deference by an appellate court. That's very different from the argument that's been put forth by appellant, which is that the trial court judge weighing the facts of a case, of a dispute, has to somehow give great deference to a lay witness's interpretation of an internal procedure or guidance document. So I think the appellant has misconstrued the deference issue. In fact,
this is an agency rule. Apparently, one would assume that, like a jury, they would follow the law. They would have considered their own rule, and they nonetheless issued a title.
Exactly right. Exactly right. And I guess the counter to that would be they didn't recognize, if you assume this reassignment supplement is necessary, which it is not, there's no statutory authority that says it is, then they saw that document with two signatures on it. And now it's Medina's assertion after the fact and after this crash happens that it's not her signature on the document, which goes into this whole subjective intent issue that was brought up in the Christensen case. But I also want to bring up in front of the court that Mr. Frederick himself, who is this DHS-MV employee, he says in the trial transcript at page 228 that if the Florida statutes are different from the procedure in TL10, that he would defer to the Florida statutes. He agrees the Florida statutes control. And so I think when we get to this, the first issue in this case, which is whether the reassignment supplement is a necessary document for issue to title, I think the appellant has misconstrued both the authority that should be given to this internal procedure or guidance document, and then also misconstrued the issue on deference. And that, I think, brings us to an important question in this case, which is, if that internal procedure, if the guidance document that we're talking about, TL10, is not an authoritative document, then what is the authority in this case, and what does it say, specifically about issuing title? And the answer is we find all the answers in the Florida statutes. It has everything you need to know. Florida statutes 319.23 and 319.001 are both dispositive here. And 319.001 is just the definitional portion of the statute, but its definitions are important. And 319.23 is titled Application for and Issuance of Certificate of Title. That is the controlling statute in this case. And what it says is that subsection 1 requires an application for certificate of title. That's the first thing. And let me just comment real quick, if I can, on this application. The Florida Supreme Court, when it decided Christensen versus Bowen, said the following, quoting, upon purchasing a vehicle, an owner or owners must apply to the Florida DHS-MV to have title issued in his or her name. This is the important part. The application, with no reference to any other documents, the application must be attested to by the applicant under penalty of perjury. Thus, each applicant knowingly enters into joint title ownership. And there's no dispute that Dr. Medina signed the application for title, at least not at trial. There was some dispute about that beforehand, which I included in my brief, but at trial, Dr. Medina finally admitted that she signed the application for title. And the Florida Supreme Court has said that when you do that, you knowingly enter into joint title ownership. That's the application for title. And then the statute requires a couple other things. It requires a fee to be paid to the agency. It requires, if the vehicle is new, a certificate of origin, and then under subsection 3, something to show that the person who's buying the vehicle is the owner. A bill of sale will do. And that's it. By statute, that's what's required. And that's what was provided to the DHS-MV to issue title in this case. And then lastly, we look at 319.001, the definition section. And it reads, certificate of title means the record that is evidence of ownership of a vehicle. And that is the entire law that applies. And by the way, the trial court had all of these statutes in the trial transcript at page, I think it's 329. The court is talking about all the statutes it's received and will review in issuing its opinion. And it's got 2D19-3983. It's got the definition sections and all of the other statutes that have been mentioned so far. So the court has those. It's got the internal procedure document, and it can weigh which one to give authority and which one to not. And by the way, that's the same result that the Florida Supreme Court got to in the Christensen case. It said, we hold that a person whose name is on the certificate of title as co-owner is a beneficial owner with the right to control the vehicle. And when you're the beneficial ownership with right to control, you become vicariously liable under Florida's dangerous instrumentality doctrine. So the trial court got it right. It held that the statutes were authoritative. It did not apparently give the internal procedure TL10 the type of authority that appellant urges, and it got to the right conclusion.
Let me ask you this question with regard to the application for title. Is that form 82040?
It is.
Okay. And I'm trying to make sure I understand the application. There is a administrative code regulation 15 capital letter C-21.001 sub 2. It says, upon receipt of a completed 82040 form, the satisfaction of all statutory requirements and the payment of the fee, the department will issue a certificate of title to the applicant. So you're arguing basically what this rule says. Is that correct? That's what
it is, Judge.
And that's the rule that the department has been promulgated pursuant to statute.
It is, Judge. And you've got the Florida.
I mean, I don't know, remember if this was cited or I found it while I was trying to work my way through the administrative code.
So it was not cited, Judge, and I haven't talked about it. It's not in any of the briefs. But I think that what you just cited, that administrative site there.
Administrative code.
And the administrative code is exactly in line with what the Florida statutes say. So I think you can either the administrative code or the Florida statutes, they both seem congruent.
Because statutes give authority for the promulgation of an administrative code, generally speaking.
Right. And so, Judge, so the question becomes then, so that the question's not hanging out there. If the reassignment supplement isn't necessary in our case, so what is that document? What's it used for? What's its purpose? And that answer is actually found in the Florida statutes as well. And it's Florida statute 319.225 subpart 3. By the way, this is another statute that was provided to the trial court judge for review. And what that statute talks about is reassignment of title. And it says in the second sentence in that subsection, it says, when all dealer reassignment forms provided on the back of the title certificate have been filled in. In other words, so the actual title, when you get a title, on the back of it, there are spots where you can transfer ownership, and you put the buyer's name and you sign it over and you say, I'm reassigning title to this new purchaser. It says, when all those spots have been filled in on the title, a dealer may reassign the title certificate by using a separate dealer reassignment form issued by the department. So there's the answer. When the actual title, when all the spots are filled up, then you use a reassignment supplement, which makes perfect sense when you consider the title of that document, a motor vehicle title reassignment supplement, which supplements the original title once all the forms have been filled out. It just gives you more space. And so that's the answer. And that's in Florida statute. So you've got Florida statutes telling you what you need for issuance of title, and you've got a Florida statute which tells you what this reassignment supplement is for. And the trial court had all of those statutes for its consideration and reached the right conclusion. I've got a few minutes left. I want to talk just briefly about the damages cap issue. I don't think the court's obviously well versed on the merits of that argument under the Ortiz versus Regalado case. But I don't even think the court gets to the merits of that discussion. It's been waived below, both procedurally and substantively. Procedurally, there was a motion filed regarding the issue. A response was written. There was a hearing that was scheduled, and then the hearing was canceled and abandoned by the appellant below, never raised again to the trial court. So the trial court never had an opportunity to weigh this issue. And this argument that it would have been futile to do so, I also don't think that's supported by the law cited. For example, appellant cites the State versus Walker. In that case, the trial counsel raised a general objection to what was happening at trial. During the discussion, the trial court had a conversation about a specific issue, and then I think overruled the objection. On appeal, they said, well, the trial court should have come back and raised a more specific objection afterwards on this issue. And the appellate court said, no, that would have been futile because the court had already discussed the specific issue in response to the general objection and had ordered it and had already ruled on it. So it would have been futile for the trial counsel to raise another objection regarding this specific issue. It had already been discussed. That would have been futile. But I'm not aware of any case, and I don't see any cited, that says where there's an appellate decision on point, trial counsel can just never raise the issue and then argue it would have been futile because there's contrary law. And so my position would have been denied or overruled. I don't know of any law that supports that proposition. So that's the procedural waiver. It's also waived substantively. After the trial on liability in this case, the parties agreed to enter into binding arbitration. And we did so by stipulation, and that stipulation was ordered on by the court. And the court ordered that the parties will be bound by the terms of the stipulation reached between the parties. Part of that stipulation said expressly, and I'm quoting, and that stipulation for the court is in the record at page 1289 and 1290. It says, the parties hereby agree to waive any and all appeals of the arbitration award on causation and damages. So all issues regarding causation and damages are not ripe for appeal pursuant to a stipulation between the parties. So I think the court never even gets to the merits. So I think the request by the appellant for in-bank review, it doesn't apply because you don't even get to the merits here. It was waived by the parties below. Unless the court has any questions, thank you for your time. That's all I've got.
I have a brief question. I just want to know, okay, assume for argument's sake that someone is buying a car, a child, and the parent is on the loan, but not intended to be on the title. And paperwork goes to the dealership, and whether it's either fraudulently signed or parent signed it by mistake, that I don't want on the title. What process would you suggest that that person should follow to get their name off the title? And is it your position that as long as their name is on the title, even if erroneous, that they would be liable for anything that happened to the vehicle?
To answer both questions, the first one is there is a process that's, and I believe Mr. Cohen referred to 2D19-3983, where if title is issued erroneously, then there can be application to the department to reissue title correctly. There's a whole process, by the way, that you have to go through to have that done. You have to take the old titles, give them back to the department. They issue a new title. I assume new documents get signed. None of that was done.
So you're in agreement with what he described that would have been the proper process for Ms. Medina to have gone through?
Yes, Your Honor. And I'll note that the second title in this case was issued after the crash at issue and was effectuated by Dr. Medina, which also demonstrates that she had dominion and control over this vehicle by effectuating an additional title transfer. If that original title was in fact erroneous, she would not have been able to change the title because she wouldn't have the statutory ability to do that. And then to answer the second question, which was if title is issued, are you automatically an owner? I think the Christensen court said yes, unless you can show evidence that it was issued erroneously, which again means you have to do the evaluation.
Well, and that was what my question is. If it's issued erroneously,
I think if it's issued
your position
erroneously,
that the liability attaches, even though there has to be some time to go through the process to take you off the title?
I think if you had no dominion or control over the vehicle and title was just erroneously issued, then what you'd hold would be naked legal title. So you'd have title in your name, but no beneficial ownership, which is different from our facts. But I think there you might hold naked legal title, but you wouldn't be vicariously liable because you didn't have dominion or control over the vehicle.
Thank you.
Mr. Cohen, you have 4 minutes remaining, counsel. You need to unmute, sir. There we go.
Thank you, Your Honors. And just to apologize, my screen went blank when I was arguing the first time. So if I wasn't looking at the judge who was speaking, I was just looking straight ahead. So
that's what we're all doing, basically.
Okay, great.
We can't tell who you're looking at.
Yeah, we have no clue.
Okay, great. Let me just make a few brief points. With respect to what forms are required to be submitted for issuance of title, counsel discussed section 319.23, which is obviously the most important statute here because it talks about the issue. But critically, when it's talking about a certificate of origin, it's referring back to section 319.21, which in turn talks about a certificate of origin on a form that's approved by the department. The form that is approved by the department is the form, goes into the issue of conformance versus non-conformance. And the department, in those TL10 procedures, they state quite clearly that if it's a non-conforming certificate of origin, then a reassignment supplement is necessary. And I think it is appropriate that the court looks at the DMV forms and DMV procedures in determining whether or not the title was properly issued here and whether a reassignment supplement was necessary. And I would point this court to the Christensen case, and I would point, in fact, to the exact same part of the Christensen decision that counsel was referring to before, which is the very bottom of page 503 and the top of page 504. And what Christensen says is, upon purchasing a vehicle, an owner or owners must apply to the Florida Department of Highway Safety and Motor Vehicles to have title issued in his or her name, citing the statute 319.23. And then, as counsel said, the application must be attested to by the applicants under penalty of perjury. Interestingly, there's not a citation to ID, and there's not a citation there to another Florida statute. Instead, the citation given by the Supreme Court in Christensen is to the Florida Department of Highway Safety and Motor Vehicles application for certificate of title with/without registration 212 available at, and then the department's website. So clearly the Supreme Court in Christensen, when deciding what was necessary for a proper application of title, was comfortable looking at the forms promulgated by the department. And we believe that in this case, this court should do the same, and that a reassignment supplement is necessary. And just to finally wrap up, I know that the Ortiz case was, the panel consisted of both Judges Casanueva and Judge LaRose. One of the cases we cite on the futility issue is the Arts case, which Judge LaRose authored. And very briefly, it's not precisely the same, but the circumstances are analogous. In the Arts case, you had 160 firefighter and police and department employees who retired, and part of the retirement deal with their employer was that there was going to be a special bill passed to approve their retirement rate. And what wound up happening, you didn't wind up with a special bill, and a subsequent bill was passed and approved at a different rate. These retirees tried to have the new rate applied to them. They were told no because they were already retired. A certain group of those retirees exhausted their administrative remedies, but not all of them. The group who exhausted, as well as several who didn't, filed a lawsuit. And the issue was whether or not the people who did not exhaust administrative remedies should be barred for failing to do so. And this court said no, it would have been a futile act because we know the result would have been the same. In this case, there was only one thing that the trial judge could have done when presented with the motion that was filed, which was to deny it. There was no discretion. There was nothing. If the court had ruled in Dr. Medina's favor, it would have committed error under Ortiz. And for that reason, we believe that it would have been futile to object. And the very last point is with respect to the arbitration agreement, Dr. Medina is not challenging the findings made by the arbitrators. It's just the application of the statute to those findings. And with that, I would thank the court for its time. We would ask that the court reverse as set forth in our briefs.
Thank you, counsel. Thank you both for a very fine presentation. Please stay well, and perhaps in the new year, we'll get a chance to hear oral argument face to face.
Hope so.
Thank you, Your Honors.
Thank you.
Take
I'll
care.
let you go. For the members of the panel, they're going to try to connect us through the iPad or whatever. Thank you.
Thank you.